Greetings everyone, my name is Jonathan Bailey. I am from the website Plagiarism Today, which can be found at plagiarismtoday.com, and today we have a significant update to the H3H3 lawsuit. The defendants have responded. Ethan and Hila Klein have answered the lawsuit and have filed a motion to dismiss in a bid to get this lawsuit tossed out just as quickly as possible. Now, to quickly recap this lawsuit, Ethan and Hila Klein run the popular YouTube channel H3H3 Productions along with a secondary channel. On that secondary channel, they did a reaction style video where they took clips from a Matt Haas video, aka the Bold Guy, and made fun of his rather bizarre style of pickup video. I don't really understand Matt Haas's channel, but obviously the Kleins found plenty humorous in it and spent some good time lampooning it. Matt Haas took umbrage to this and filed a copyright infringement lawsuit. And that's when things got really weird. Long story short, though, the Kleins put a plea out on, well, not really a plea, but they put a video out about it. They specifically did not ask for money, but the internet responded anyways and created what's known as the Fair Use Protection account. And that account is with the law firm of Morrison and Lee LLP. Ryan Morrison being better known as the video game attorney, and Michael Lee, his partner. They're using that account to defend this lawsuit, and now Michael Lee, their attorney, has filed the motion to dismiss. Now, for the full recap of this, by the way, and everything that happened before, check out my previous videos. I'll put them in the description, a much more thorough retelling of the story. But anyways, motion to dismiss. Let's move on. Yes, the motion to dismiss was filed on the 27th, and long and short of it is, this is a bid to have the lawsuit dismissed before the legal issues are really raised. You see, a motion to dismiss is kind of the first step in the process for how a lawsuit can get tossed before it reaches a trial. In this, the defendants, the Kleins, are arguing that the facts of the case as presented by the plaintiffs do not rise to make a case, basically, that this is not actually a valid lawsuit. And as part of that, you're not going to see a lot of legal arguments. For example, everyone's very interested in the fair use arguments. You're not going to see that too much in these arguments. Yes, fair use is mentioned briefly, but it's very passing. The goal here is to just simply prove that the facts as presented do not add up to a lawsuit. Now, in addition to the motion to dismiss, which is just basically a couple of pages saying, please dismiss this lawsuit. And by the way, once again, all PDFs will be in the description. There were three supporting documents. The first was a statement by Ethan Klein, which you can read, but basically it just recaps everything he said in his YouTube video describing the lawsuit. It's what he did, what Haas did, sort of the lead up to the lawsuit. You also have a statement from the attorney, Michael Lee, who basically is examining the copyright registration, which becomes really important in a minute. Now, this is where we have to take a brief aside. In the United States, in order to bring a copyright infringement lawsuit, you must have a valid copyright registration. This is how federal courts have jurisdiction over the matter. Now, I said in my previous video that's kind of strange for a YouTuber or a blogger to have a valid copyright registration for their work, and it is. And a lot of that's because, to be frank, our copyright registration system just sucks. It really flatly sucks. It is burdensomely expensive and needlessly complicated for registering blog posts, YouTube videos, and all that jazz. It's not too bad if you want to do like an album or a CD or something and anything that's a traditional print, but for rapidly updating things like YouTube channels or blogs, it is a mess. Long and short of it is, according to Michael Lee, their attorney, the copyright registration that Matt Haas is using in this lawsuit is valid, and that is really the crux of what he says and the meat of the argument, which was contained in this memorandum in support of the motion to dismiss. It's a rather lengthy document, but long and short of it, you can see here in the table of contents. Basically, he says the registration is completely invalid, and his argument on that hinges upon two things. What Matt Haas basically did for the copyright registration was he uploaded a bunch of his videos to the U.S. Copyright Office and labeled it an unpublished collection of work. Now, according to Michael Lee, not only is it not unpublished because it's been on YouTube and it therefore does not meet the Copyright Office's requirements for being quote-unquote unpublished. It doesn't meet the requirements for a collection because it's actually several different series, or at least 2 different series of videos contained within a single collection. So basically he's saying that it was misfiled by both being actually published and B, by not being a proper collection as per the U.S. Copyright Office. And as I said, no valid copyright registration, no lawsuit. And so that's really the argument they are making right now. Fair use is mentioned, but it's only a very passing mention. If the lawsuit does survive this motion to dismiss and moves on to the next stage, what will happen is both sides will file motions for summary judgment. And that's where they make their legal arguments and they try to make the case that there's no reason for this to reach a trial or a jury. Our facts and our legal arguments are so sound, no reasonable jury could ever rule against us. And then the judge would rule without taking it to a trial if he or she agreed. However, like I said, this motion to dismiss simply looks at the facts, so we're not going to get that fair use argument at this time. Now, as far as the likelihood of this to succeed, I think it's actually pretty good. I mean, it's like I said, our registration system is hopelessly complicated and burdensome. It would be kind of sad and frustrating if this were the reason the lawsuit was won, because it does mean bad things for all YouTubers. It means there's almost no practical way that you can completely register your YouTube channels and protect your work. But that being said, Michael Lee would not be doing his job as an attorney if he didn't raise these arguments. So he's doing the right thing, basically. So, all in all, I think this has a pretty good chance. I will be very interested to see how Matt Haas's team responds to this motion to dismiss and what they have to say about it. But that's where this lawsuit sits. Michael Lee and the defendants here are starting out by challenging the copyright registration. You can say this is something of a technicality, but it's a very important one in U.S. copyright law right now. All in all, it's an interesting case moving forward, and I'm definitely going to keep track of this because now it involves more issues that I'm interested in, copyright registration being at the forefront of something I'm very passionate about. So yes, much for me to sink my teeth into this lawsuit, and I hope to take you guys along for the ride. Well, on that note, everyone, thank you very much for joining me, and I will see you guys next time.